Credibility. It's the sine qua non of jury trials. Sine qua non. I took one semester of Latin back in 2002 in high school. I still remember that sine qua non means without this, there is nothing. If you don't have credibility in a jury trial, you're going to lose. And there's so many places where you're going to lose, and it begins well before your jury trial. So I want to talk to you today about what the issue of credibility means, which basically means making sure that the truth is on your side, that you're telling the truth. My name is Vlad Genshu, and I am a civil jury trial in the state of California. I have tried 11 civil jury trials to verdict. I've also tried one more that settled during jury selection, and another one that settled right before the jury was to go out to deliberate before I did my plaintiff's rebuttal. So I want to talk about credibility. First of all, we talked about bias before. We talked about it a lot in the jury selection videos. And the issue of credibility is relatively straightforward. It's simple yet profound, which is you got to think about this first, not just as an attorney, but as somebody who is taking up the issue of a personal injury case into court. As the plaintiff's attorney and representing the plaintiff, you being the voice, you start out behind in almost every courtroom in California. And there's a reason for that, right? The credibility of your client is going to be questioned, not just due to legal issues, you need to prove your case, but because of economic issues, cultural issues, political issues. I've been practicing law for about almost 10 years. It'll be 10 years on December 4th, 2023. But for those who've been practicing law for a longer period of time, they remember that in the 1990s and into the 2000s, there was the tort reform wars that were going on in California and nationwide. And part of those wars, tort reform or tort deform, as Ralph Nader would call it, is you had insurance companies and doctors demonize personal injury trial lawyers to the point that younger trial lawyers don't remember this, people who've been doing this for less than 10 years, but people who've been watching politics their entire life and following it like the sports pitch know that the term trial lawyer in and of itself is a very, very much negative word in the business community. It's a negative word among doctors. It's a negative word among small businesses. It obviously is a slash and burn to the ground word among insurance companies. And that was created during the 1980s, 1990s, and into the 2000s. I think the high point was the 2004 presidential campaign. These are legal videos that I'm making here on YouTube. They're not meant to go into politics, but you need to understand what situation you're going into as a plaintiff and a plaintiff's lawyer. And the reason you need that is very common sense. The jurors you're going to go get are obviously minimum 18 years of age. Now, obviously, when you get an 18-year of age person, that person's most likely not going to remember about the 2004 presidential election. My math might be a little off, but they might have just been born in the year 2004. So they're not going to remember, Bush versus Kerry. They're not going to remember how, Bush tried to, really burn down John Edwards, a plaintiff's trial lawyer who was John Kerry's running mate. He was a U.S. Senator from North Carolina at the time. He's not going to remember that. So you're okay with the 18-year-old. You're probably okay with the 22-year-old. But there's going to be jurors on that panel who are in their 50s, who are in their 60s. And if you're trying a case in Riverside or San Bernardino or Orange County or even in parts of LA, there are going to be small business owners. There's going to be people who do not like and get a bad taste in their mouth about personal injury cases. And that's also another topic during jury selection. You get a lot of lawyers saying, if this was a pie eating contest and you don't like cherry pies and you got a cherry pie and an apple pie, you're never going to like the cherry pie no matter how bad the apple pie is, right? So you shouldn't be on a personal injury jury trial. That's true, but I want to tell you why it's true and why you're going to deal with that. Because if you don't understand this, you're not going to be able to understand how important credibility is, because you start at a deficit with credibility on the plaintiff's side all the time, okay? In the 1980s, especially in California, you had the tort reform wars in the state legislature. For those who remember, in 1986, 3 justices on the state Supreme Court were defeated for re-election. You had Chief Justice Byrd, Justice Grodin, and Justice Reneso. They all lost re-election in 1986. The issue officially on paper was the death penalty. But if you really look at who funded it, it was the insurance industry. Insurance industry are very, very smart people who are out to make money. That's perfectly fine. We got a capitalist economy. But what you got to understand is they got rid of 3 justices in part. And part of the reason was because they said car insurance is going up. Businesses are paying too much money because of what they consider to be a very much pro-plaintiff, pro-consumer civil justice system. And they got rid of 3 pro-plaintiff, we'll call them pro-consumer justices on the state Supreme Court, where after that, the governor at the time, George Duke Majan, was able to replace them with 3 pro-business state Supreme Court justices who went on to serve for a very long period of time. 1986 is a long time away. That's the year I was born. But at the end of the day, that still happened. And you're going to get jurors who remember that. And if you think that this is going too much into civics, this is boring, I'm a lawyer, why should I listen to this? I listened to a jury selection about last week. It was a medical malpractice case. This juror did not sit on the jury, but he did say this during jury selection. Number 1, he was an attorney. Number 2, he was an insurance defense lawyer. Number 3, the case was a medical malpractice case. And number 4, he went into MICRA, left, right, north, south, center, basically saying how much these cases should not go into court. None of these cases should be tried. We're losing our doctors because of these cases. I'm so proud to have been part of the 1975 MICRA effort, this, that, and everything else. He never sat. That juror never sat on the case. Simply, again, we mentioned this in the jury selection video, simply by him saying, I don't think the case should go to court, done, poof, you got him out. Fine. But that's like looking at the case with one juror at a time. And that's the way it's got to be done. But you got to understand, when you enter a courtroom as a plaintiff, you're starting at a deficit with credibility because of jurors' life experiences during the tort reform wars of the 80s. All right, we can go into a lot of detail about that. We can go into the napkin deal that was done at Frank Fast's restaurant in Sacramento, how tort reform, how a med mal was reformed, how attorneys were allowed to take a little bit more money, how cases were given a little bit more time to be filed. That's all fun and very interesting. If you're into politics, you'll get a really good feel of what you're dealing with. It's something that would make this video a little bit too long. So, I think that a lot of lawyers just rather abbreviate that. But remember, you're dealing with people whose life experiences, if they're 50, 60, et cetera, in their 40s, 50s, and 60s, who remember that. Going into the 1990s, all of us who do personal injury work know Prop 13. We don't really know how Prop 13 was put about, right? Prop 13 was put by the insurance industry, again, not to say, hey, let's try to make it hard for people to get non-economic damages. No, it was meant to protect law enforcement from being sued. And at the end, it said, oh, by the way, you also have to be responsible and get your own insurance yourself. So you kind of see a pattern there, and it's really a smart pattern. I don't know if it would work anymore today, but the reason why I'm saying this is you have to consider you, the plaintiff, and the plaintiff's attorney, how tough, if your lawyer is not a good lawyer and if your case is not a just case, you are going to have, because you're dealing with these jurors, right? We could go into some more stuff. I'll just tell you this. It took until the year 2021 for the MICRA $250,000 cap to be increased, not gotten rid of, increased. And that was done through the work of Governor Gavin Newsom and our state legislature and brave plaintiffs lawyers like Nick Rowley, who were able, to show the truth and how MICRA didn't really lower insurance premiums, but it was only hurting really disadvantaged people and in a horrible way. They weren't able to get access to justice. So it took until 2021 to increase MICRA from $250,000 to $350,000, with it being capped at $750,000, I believe 8 years from now, and then adjusted to inflation from then. So it really hasn't been gotten rid of. And then if you really want to know the last piece of information on this, in the year 2014, the plaintiff's bar put Proposition 46 on in front of the voters, in front of the November 2014 general election, and it was to just to index the 250,000 1975 cap, micro cap, to inflation. Governor Brown, who signed the cap back in his first term in 1975, one of the first things he did not endorse Prop 46. It lost by a vote, I believe, of 64 to 36, losing in every single county, right? This is a very progressive Democratic state of California, and just to index micro, to turn it in from 250 to, I believe, would have been about 1.2 million in 2014, and then continue it at a COLA, a cost of living adjustment, that also failed. What does all that have to do with anything? That has to do with understanding that that is the environment that every personal injury case goes in front of, which you have a very skeptical, if not cynical, jury pool, right? Obviously, there's different parts of the state. We have 58 counties in the state of California. Different parts of the state will view a personal injury case differently, right? If you're going to try one in Riverside County, that'll be different than San Bernardino. If you try one in San Bernardino, that'll be different than Kern County. You try one in Kings County, that'll be different than one in Kern County. You try one in LA County, there's many courtrooms in LA County. Now we're going back to independent calendar courtrooms, to, if you will, community courtrooms, as opposed to the personal injury hub. It's going to be a different jury pool. You got to keep that under mind. There is no hard and fast rule. Skepticism, in my opinion, exists throughout the state, including in the Bay Area. So here's how I view this. If you're going to look at the issue of credibility, without credibility, you don't have a case. There is nothing else without credibility. So you got to start with the first and most obvious aspect, which is when you took the case, when you either it was referred to you for trial, or if you took it from, it was your baby from day one, it was given to you. You signed up the client, if you will. You signed up the client, you took it. Is this really a meritorious case? If it's not, you should not have brought it, and you shouldn't bring it. You should tell the client, I'm sorry. You have to think about every case as if it's going to go in front of a jury. And in my opinion, this is going to be a tough one in front of a jury. I just don't think this is a good case. That's it. You have to be honest with the client. You have to look at the matters of liability. You have to look at the issues of compensation damages and ask themselves, is this going to be something that is worthy of taking the court's time, jurors' time, potentially, your time, and the client's time, right? You're never going to get any of that time back, right? Even if you think you're doing your client a service by preparing them for a deposition or, doing excellent responses to discovery, telling them all about the process, you're still expending the client's time. You're expending the client's time. And you need to understand the client is not going to get that time back. So you need to be frank and honest with yourself. If you don't think you can get compensation for your client, you don't think this case is a meritorious case, you don't think this case should be brought, then you shouldn't do it. You shouldn't do it, because at the end of the day, the insurance companies handle 400, the average adjuster has 400, 500 files open. They've probably handled tens of thousands, if not tens of thousands of files, depending how much seniority they have with that insurance company. They'll see through it. The jury will see through it. Only take meritorious, just cases. So that's your first credibility marker right there. And as a personal injury lawyer, if you're looking at a car accident case, you're looking at a slip and fall case, you're looking at a trip and fall case, you're going to have to ask tough questions. You're going to have to ask tough questions of your client. How did it happen? You're going to pull up a Google map and see where your client coming from. All these questions are going to be asked by the insurance company's attorney. So you better ask them first and get the answers out yourself. Make sure that the client's telling the truth. Make sure that make sure that you can stand by this thing. Okay. And then when you're in litigation, you got to make sure that, look, most of these videos are about trials, specific things about, jury trials, specific things about jury selection. We're going to do one about cross-examination. We're going to do one about direct examination, closing argument, rebuttal, direct opening statement. 98% of cases settle, right? Most personal injury cases, they don't even go into a lawsuit stage. They just settle at the claim stage, claim presentment stage. So what you need to look at is you need to give accurate, truthful information to the insurance company in a timely manner so that the carrier knows, the insurance carrier knows, the insurance company knows, here's the theory of liability. Here's what happened. We're not hiding the ball. and here's what we're going to do to see if we can settle this. California has now increased its, if you will, law with more teeth in terms of settlement. It's a California Code of Civil Procedure 999, which makes it an insurance company, you can, if you will, open a policy within 30 days once you give a settled policy limit settlement demand, which can be done pre-litigation. You just have to, obviously, you have to give the insurance company enough information in order to, for them to be able to determine the risk in terms of liability. If they're insured, their customer, person who rear-ended you, or the store you tripped and fell at, or the dog owner, if they are liable, if it's their fault, and what are the damages. So you got that. That's something that starts in pre-litigation. Not much of that is going to get into litigation, but definitely it's going to be the same fact pattern you're dealing with, right? You're still dealing with the same injury. You're still dealing with the way it happens is going to stay the same all the way up until the end. So that is the pre-litigation part. When you go into litigation, credibility is extremely important, which means you got to know your case. Again, you've taken this case, you've signed up this client, they signed a retainer fee, a retainer agreement, and you're looking at a case which, for the most part, in a personal injury case, is not going to change from the time you signed it up and the time you're in litigation all the way to a jury trial. You're going to have full knowledge of everything as the plaintiff's lawyer, which is a massively beneficial set of circumstances. In a business dispute case, business litigation case, real estate case, the facts might change. You might not know all the facts as the attorney because you don't own the business, and the business owner does, you don't. So in a personal injury case, you know how the car accident happened. You have the police report. You could go to the scene. You can ask the client. You can ask anybody else who is a passenger. And you need to test hard that credibility. You need to sit the client down. And if you will, in presidential debates they have before the debates happen, you have a member of your party prepare you for the debates. They're called murder boards. And what happens is you basically have somebody, sit there and ask you tough questions about the economy, about this, Mr. President or Senator, da-da-da-da-da-da. You need to ask your client tough questions. Why did you wait 2 weeks to go see a doctor? Why did you do this? Why did you do that? Why did da-da-da? All that stuff is in preparation for trial. And that is the issue, credibility. Cross-examination happens at trial, but it should happen in the attorney's conference room, or over the phone, or at a Starbucks, or at a California pizza kitchen where I like taking clients to. You got to ask them the tough questions. Cross-examination is the way the truth comes out. And if you don't find out early on the truth, and if you got to make sure that you got to make sure that truth is in your favor. If it's not, you got to consider dropping the case, right, or settling it, because you can't take one of those cases to trial. So you find out the truth, you get the truth, and what do? Well, if it's a good meritorious case, you move forward. And if you don't, you drop it. You got to be honest with yourself. So you need to evaluate the case neutrally, because that's what the jury's going to do. That's what they're told to do. And defense counsel is going to do everything they can to poke holes, right? To counterpunch, to take bricks out of that wall that you're trying to build and to collapse your case. And it's going to be very easy to do that if you have credibility problems. The client needs to tell the truth. You need to tell the truth. You need the truth to be on your side. So this is where I think the aspects of credibility, both with the truth and the case being on your side, and with your credibility with opposing counsel matters, which is basically, number one, tell the truth about your case and tell the truth to defense counsel. That is how you are an ethical lawyer. And that does not mean that you're a weak lawyer. That means you're an ethical lawyer. And those are some of the strongest and most dangerous trial lawyers, because the lawyer that does not brag the most and says, okay, fine, I'm sorry, I took your offer to my client and we're going to try this case. That's the most dangerous client. That's the most dangerous trial lawyer. Especially if the insurance company knows, this guy tries jury trials. He means what he says. He's not about bluster. His negotiation is not one lie after another. It's the truth. So let's talk about telling the truth to defense counsel. Simple things. You filed suit. You've sued their defendant. You now contact, this is one of the things some people do this. In LA County, you have 60 days to serve the suit. You get on the phone, you call defense counsel. You say, or you call the insurance adjuster who you've already been dealing with, let's just say, from pre-litigation. I've just filed suit. I can serve it tomorrow, or I can serve it next week. I want to know if you are interested in settling the case, or if we should just serve it, right? For the most part, I don't deal with this part, but it happens. So the question is then the adjuster says, okay, well, the adjuster, if it's now a pre-lit adjuster, will give it to a litigation adjuster, and the litigation adjuster will probably say, can I have an extension to respond to this suit? You should say yes, you have an extension to file an answer, not to respond, because you don't want your adjuster getting a 3-month extension and then filing and then demurring. You don't want to demur. You don't want them demurring to your case. That basically is kind of a motion to strike to kick the lawsuit out. You want them just to answer, and then you want to give them time to be able to put together a settlement, and you want to hold yourself to that. You file a case management conference, a case management statement with the court, right? Send it to defense counsel, to defense the adjuster from the insurance company, the defense adjuster, and tell the court, we gave them an extension of 2 months to see if we can settle it, and I gave them an extension to answer suit. If you want to, you can attach that in the email to the case management statement. You can do that. And then the court knows, okay, I don't have to sanction anybody now. I'm not going to sanction defendant. I'm not going to sanction plaintiff. They got 60 days. Hold yourself to that. Promise. Right? Don't go in there asking for a default. Even on day 61, don't ask for a default. Don't go for defaults are easy to remove. Don't ask for a request for a default. Don't do that. Go back to the carrier as an adjuster and say, look, you have the right to answer. That's all you got a right to do. And then they probably will just answer the suit, right? You gave them time. Maybe they'll give you a better offer. Maybe they won't. Maybe they'll just send it to their in-house attorney. Maybe they'll send it to their outside counsel. But that's credibility. You establish credibility. You call them. You said, look, you've been sued. I've sued, El Super. I've sued Ralph's. I've sued John Smith. You're insured. I know where they live. We have process servers. We can get this served. But let me see if we can settle it. I'll give you 60 days to come up with an offer if you have one. If we don't, we'll proceed to litigation. That's fine. But you got 60 days, and you can answer the suit in that time. You can't respond. If you want to demur, you have to demur now. I can't stop you from demurring, but you got to demur now, right? So, and that is something that an adjuster will very much appreciate. It's not going to get you $1 million settlement. It's not going to get you way more than what what they were thinking of giving you, but it establishes a good rapport, and it establishes credibility. Because remember, you made a promise. Credibility is about making promises and delivering on them. So you made a promise to the adjuster, and you delivered on it. Okay, when's the next part? Let's just say they say, listen, we just don't think this, here's an extra $5,000. There's no way you can settle with that. You're like, listen, we can't. Took it to my client. My client rejected the extra $5,000. I'm sorry, we're gonna have to move forward, and your extension expires in a week. They answer suit. They do what they said. One of the things, one of the options you gave them, they answer the suit, and now you're in litigation. Okay, what's the next stage of credibility? Discovery, written discovery, simple, basic things. My opinion, don't play games. Everybody is entitled to figure out. Remember, I said the vast majority of cases, 98% never see a jury trial. Probably 99% if you take all the ones that settled before going to the lawsuit stage. So what do? Most cases are meant to be settled. Let's be frank, right? So you got to be accurate and respond to discovery. If they send you a lot of discovery and, it's near the holidays, near Christmas, Thanksgiving, and New Year's, whatever, just say, look, I need an extension. I need a month extension. Call the defense counsel. Get on the phone. Don't just write an email. You can confirm it with an email. Call the phone. Listen, I'm going out of town a couple weeks. It's going to be hard for me to reach my client. Obviously, I need to get the verifications for you. Can you please give me a month extension, and I'll get you the responses? He says, yes. Okay, confirm it in an email. You got your month extension, right, to respond to, the discovery with verifications, right? Now, here's the important thing. Get the responses within a month. Don't go back and saying, I need another month. I need 2 more weeks. Just get the responses, especially if it's a straightforward, relatively simple form interrogatory, special interrogatories, request for production documents. Just get the defense lawyer the answers, the responses to discovery, verified in the time that you promised him or her. Okay? Get that done. The next aspect of credibility. You just got yourself credibility points there, right? The next aspect of credibility. You ready? Your client's going to be deposed. Okay? Tell the truth to the defense counsel. Listen, look, that date you gave me doesn't work. I'm going to give you 5 dates where you can take a Zoom deposition of my client, 10 a.m. and 2 p.m. Here you go. Or my 2 clients, or my 3 clients. There you go. When that date happens, have your client be deposed. Obviously, prepare your client before they're presented at the deposition. But meet that deadline, right? These are simple things that you're really taught in high school and elementary school. But you'll be surprised how many lawyers lose credibility with the other side, and their relationship turns into, if you will, arthritis, which is the gel that holds together society, that common trust just erodes, and now it's bone on bone. It's just so tough because you didn't keep your promises. All right. This is all going to make the relationship be much smoother when and if the case goes to a jury trial. Much, much smoother. So once the deposition happens and occurs, make sure you present your client right at the deposition. Make appropriate objections. That's fine. No one's saying don't represent your client, but just make sure you get it done on time. Otherwise, how are you going to be able to settle the case if the insurance company, if a good settlement's going to happen, the insurance company has to get the information from their attorney, which means that your client has to be deposed, and then your client has to have the discovery responses in. Okay. Vice versa. You're going to send out discovery to the other side. If they need an extension, you give them an extension. Okay? So on and so forth. Common courtesies. You'll be surprised how few people actually do this. Get on the phone and talk to defense counsel or plaintiff counsel, depending which side you're on. Don't just fire off an email. And don't fire an email off. Don't email somebody when you're angry. If for whatever reason defense counsel wrote you a snarky email, don't reply back. Remember, your reply back, it's there set in stone forever. Do not reply back when you're angry. Don't do that. This is the most common sense video I've ever made. And yet it's extremely important because it's going to set the stage for the other videos about trying a case. If you've nuked your relationship with defense counsel, you're going to end up doing a whole lot more work preparing for trial because they're not going to cooperate with you. And if you're a plaintiff's counsel and you have a mid-sized to a small firm, the defense attorney, if he or she is working for a massive law firm, they can say, okay, well, guess what? I have 2 paralegals on this and a secretary. I'm going to do my stuff. Let them do their documents. We're not going to touch their documents. And you're not going to have joint documents. The court's going to be angry. You're going to have to do everything. You're going to have to sit there at night and hole punch and go to Staples or wherever to copy stuff. And you might have had defense counsel doing that for you if you had a good relationship with them. Just try to work in the middle, please. Try to get that stuff done. That does not mean, nowhere in here have I ever said on the critical issue of money, compensation for your client, which is what this is all about. Nowhere did I say compensate. Nowhere did I say compromise on money in a way that hurts your client. I never said, nor do I ever believe, that any attorney should get on the phone and call Progressive and say, well, we have another 50 cases. I could do a haircut on this. No, never. That is unethical. But what I do think you should say is if defense counsel, she's about to give birth or his wife's about to give birth, give them a month-long extension. Be a human being about it to answer discovery. Or say, we'll continue the trial on certain issues, not for you to file a motion for summary judgment, but we'll continue it on expert depositions because I know you're not going to be able to take a good deposition while you're in labor or while your wife's in labor and you're sitting there at the hospital. That's outrageous. And let me tell you, if you don't give them that extension and the court hears about it, you're going to have a good time with that judge. Bad move. Okay, so be a human being, okay? All right. Next thing. when you're taking expert discovery, expert depositions, simple stuff. Work with the scheduling. Tell your expert, hey, they can depose you in March of 2024. They can depose you in January. Can you give me some dates? But don't email your expert, your medical doctor, your accident reconstructionist, your biomechanical expert, your biller. Don't email them the night before. Don't call them and the scheduler at 4:30 p.m. the day before the day before the depot or the day before, and say, oh, can you confirm? Oh, come on, they have patients, they have clients, they have stuff to do. They're human beings too. You shouldn't do that. It's common sense. Okay, this is so simple. The things you should fight on in the trenches, right? Fixed bayonets, if you will, is the value of the case. It's not being a jerk to get there, because I promise you, every insurance defense firm will outmaneuver you on being a jerk, right? So what you need to do is fight on the substance, right? Remember, if your case is just, which is the first thing you decided when you walked in with the client in your conference room, first thing you came to an answer. If your case is just and true, that's what you fight on with the defense counsel. When they say, no, sorry, we don't see it, you say, I'm sorry, you do see it. Here's how it is. We have a confidential mediation brief, but I'll tell you exactly how we see this case. And this is how the jury is going to see it. And you've seen it in deposition. My client is telling the truth. The medical records make perfect sense. The treatment makes perfect sense. That's what you fight defense counsel on. The substance, not the procedure of, when am I going to give him or not give him an extension to discovery? Yeah, I didn't say give them an extension to file a motion for summary judgment. That kicks your case. No, absolutely not. Right? Most cases don't have an MSJ, car accident cases, but if you do, don't give them extra time on that. Right? And if they've blown the 2034 exchange where they don't have an expert, no, don't give them time to get another expert. That's on them. They made a mistake where they hurt themselves. Right? I'm not saying to give them extra time to finish off your case to hurt your client. Never. But if they're in the right and they have the right to a discovery extension and it's justified and it's not the 5th extension, it's not the 4th extension, even if it's the 2nd extension, give it to them, right? Because your trial date's 18 months out, so it doesn't really matter. So that's what you need to consider. You fight on the substance and you keep credibility with counsel, and then you will have a smooth process to either settling the case or putting together trial documents. That's what I consider to be an effective credibility in terms of the procedure, in terms of relationship with defense counsel, and in terms of putting together trial documents. Thank you.